also be touching upon in the issue 2 of the articles. However, in case we proceed with this dispute, and in case the claimants fail and turn out as the adverse party, as per this particular paragraph, their costs would be set off in this via the award itself, and if they win, it would be duly refunded. So the very intention behind this consensus addendum was can be explained by a very simple analogy. Indeed, if I may argue it on the basis of two fronts in a chronological fashion. Firstly, to explain it with an analogy, if I am invited to scuba dive in a deep, precarious ocean, on the assurance that I would be provided with an oxygen cylinder as life support, and just as I am about to jump, this oxygen cylinder has been stripped of me, I would not jump because it would create insecurity, even probably death for me. In this particular case, in this particular clause, this 7.5% of the arbitral claim exactly acts like an oxygen cylinder. Because in case the claimant emerges as the adverse party, and there is an issue in the enforceability of the award, or there is an issue with regards to a lackadaisical nature in which the claimant would comply with the award, we would face commercial hardship, sir. And this was a major consensus addendum behind this particular clause. With regards to where it would be submitted, this particular clause is not at all silent about that, because the institutional rules that govern this arbitration clause are the CIAT rules, and hence it is implied that it would be submitted to the CIAT Arbitral Tribunal itself. Indeed, sir. Sir, with regards to the way in which it would be deposited, the clause 45.2 very clearly denotes that it will be deposited in the form of a fixed deposit receipt, and it can be deposited to an escrow account as well as whatever which may be preferable by the tribunal itself. A silence on this particular fact entails the flexibility that we have decided in this particular part, which the tribunal in itself can delay. Or we do not want these deposits for ourselves and for our own benefit. We just want that, okay, you have raised a claim, now please reserve 7.5% with the tribunal, so that in case there is any adverse award against you, it will be diverted without use of a claim. No, sir, because in this particular paragraph, we have not raised any particular quantification to the counterclaim. Sir, in case the claimant party in this particular regard would submit the 7.5% of the PDC, and if they turn out to be an adverse party, then whatever awards would come against us would be adjustable and would be set off by. Indeed, sir. I'll answer on both of them. So firstly, I would be in a better position to answer after listening to their arguments as well, but preempting such an argument, sir. First of all, how is it procedurally not unconscionable? So we did note the draft case very well in advance. We put special emphasis on the same, and there was no unconscionability with regards to any imbalance of bargaining power between both the parties, among both the parties. Because even we are still a nearly 1-year-old company in this particular industry. We do not have such a huge status in this particular industry as well, because our former clients have also criticized our way of functioning. Hence, we both are almost at the same pedestal, giving us equal bargaining powers and equal opportunity for them to not only object but also to change any particular disputation clause. This is the procedural part. The substantive part, sir, this whole arbitral clause is very accurate upon the quantification of the deposit, in what form it has to be deposited, when it has to be deposited, and for what purpose it has to be deposited. With regards regards to the silence facts, as pointed out by Sir President, it is only and only to maintain flexibility and no rigidity in technicalities with regards to us following this particular procedure. Much more thanks, sir. So proceeding to the second limb of this argument, or second submission of this argument, the PDC is not at all in contravention with the public policy. It is imperative over here to note the observations as entailed in the Supreme Court judgment from 2009 from SKJ versus State of Haryana. If I may invite the bench's attention to page number 1 of the case as submitted by this one.
Page 1 of what?
Of the case complaint, sir. It must be submitted. If the tribunal is with me. Indeed, sir. Sir, over here, the highlighted parts would denote the relevant parts of the judgment, particularly paragraphs 3 and 1, on which I would be taking the lines. Sir, the general intention behind the pre-arbitral deposit clause has been entailed in this particular judgment, where the Supreme Court of India says that such a PDC is there to aid arbitration, is there to aid the system of arbitration by dismissing frivolous claims, by dismissing vexatious claims, and upholding the dignity of an arbitral tribunal and thus gravitas of seriousness behind its award, sir. Secondly, it also entails in the judgment that it is a very common industrial practice which encapsulates the foundational principle of arbitration in India, that is upholding party autonomy of both the parties, especially in a private transaction like this one, where there is no state party, unlike in the judgments of Lombardy as well as Icon Limited. Hence, in this particular paradigm, when there are two private parties, party autonomy has to be paramount consideration, sir, because of which we place our reliance on the judgment of this state. If I may be allowed to proceed.
Sir, one question was, speaking of party authority and agreement that you remember, you also agreed to incorporate the SISG rules. As you know, the SISG rules provides a mechanism for the institution to estimate the cost of arbitration and ask parties to make deposits with the cost of arbitration. So if that is the mechanism that you already signed on in your arbitration agreement, why should the tribunal impose upon the an additional deposit mechanism beyond what is already prescribed in the institution rules? It is of course quite different from cases that you refer us to, where there was no such mechanism already in place because there was no such institution administering those arbitrations.
Very well, sir. Because in this particular case, when we are talking about that particular rule of the CISG rules, it refers to the cost of arbitration, which is squarely different from the PDC over here, which talks about the cost as a proportion of the total arbitral claim, which are two very separate things. Based on the cost of arbitration, the CISG institution has complete discretion, upon which we would also argue in a further length, sir, if I must be allowed. Indeed, sir. Sir, with regards to the Lombardy judgment, which also refers to the Icon judgment, it was very well contended and also accepted by the Supreme Court of India that the contentions with regards to Article 14 are in this context very specialized, wherein the state has been acting arbitrarily and unconscionably against a private party. In these paradigms, sir, the state naturally has a higher bargaining power when compared to a private party. However, in our paradigm, sir, with both parties being barely experienced in the industry as well as private in nature, there arise no such questions regarding arbitrary nature and a position of higher bargaining power. No, sir, not in that sense. Because when we look at the Icon judgment, it was very well ruled that any sort of security deposit of such a PDC, wherein a forfeiture has been asked for, is amounting to being in contravention to the public policy. Now, in our paradigm, sir, we are not greedy enough, as they would portray us to be, to even take their security deposits and forfeit it for our private benefit. We only require them to post it to the tribunal in case any adverse award comes against them. It can be sent. So proceeding to the second limb of our issue, that is the security for cause shall be ordered against the claimant. Sir, if we look at the permanent code of arbitrations award in the case of Tenant Energy versus the Government of Canada, it lays down certain thresholds in which security for cause can be imposed on a party. Firstly, sir, if any party is in a gross misconduct, which relates to the derailment of the execution of an agreement or the dispute resolution mechanism itself. Secondly, sir, if they are acting in a professional incompetence, then this may arise. And third, sir, if they are acting malafidely, then it may arise in any one of these situations. Unfortunately, sir, we have to concede to the fact that the claimants have been acting professionally incompetently and in gross misbehavior in this particular paradigm. With regards to an unsubstantiated legal threat, as placed in the letter dated January 19, 2023 by the claimant, moreover, a non-compliance with mandatory pre-arbitral conditions. In addition to the same, sir, a dubious act by the chief engineer, Ms. Melisandre, from the claimant side, by transferring our confidential data, as denoted under clause 38 of the DSA, to an unauthorized device. So these acts surely warrant a conduct which is incompetent professionally, which has to order for security for cause under Rule 27 also. Yes, sir.
I just want to check with you the source of our power to grant such a security for cause. For a moment, tell us under the law of the arbitration, like something like that. Where is the source of our power and how does that mesh with the express powers which we have been used, which has to do with the constitutional law?
Indeed, sir. So when there is a governing law which is clear and it is coupled with an institutional law, whichever law is vague, and if there is any clarity given to it in the second law, they should be read with along in consonance. Now, in this particular paradigm, so Rule 27 Clause J particularly of the CR rules gives this tribunal the power to order security for cause. And in the Arbitration and Conciliation Act, sir, the scope, validity, and meaning of any arbitral clause can be decided under Section 16 of the Arbitration and Conciliation Act.
But are you making an application under Section 17 for an indefinite leave by virtue of security clause or not?
Not at all, sir. That's why I did not raise the Section 9 Clause 1 itself, which also talks about the security for cause, but in the context of an interim relief. This is a matter of our right, which has been guaranteed and consolidated through party authority, which is why we do not want an interim measure. And that is why we believe that while the only valid argument that the claimant may put forward might be for being temporarily exempted, this interim relief argument should be raised by them and not by us, because the right has been consolidated within the party autonomy itself. If I may seek an extension for coming to issue 2, sir. Indeed, sir. For the sake of brevity, I would like to summarize this whole issue for you. Just lend me a moment, sir. So firstly, just to contextualize in a very small manner, the claimants have relied for their contentions of our data being inaccurate based on an AI generated report named Brandstar. The AI system is named Brandstar. This particular AI system is not at all an expert through fitness and suitability as per global tests such as the Forward test and the Q1 test, through qualifications as per the general principles entailed under the Indian Evidence Act, particularly in Section 45, through cutting of judgments, wherein corroboration and scientific testing criteria of the entity's methodology is required, like Sebi Jajalalitha relying on state of Himachal Pradesh versus Jalal, as well as the Brandstar not even qualifying as a bare AI expert system, because it does not have the 3 basic components of an AI expert system, such as it being derived from a vast and an experienced knowledge base, particularly in the field of environmental data. Secondly, it does not possess any commercial experience, or it to have a potent inference engine to draw inferences from its already myopic knowledge base, especially in the commercial streams of dealing with environmental data. And thirdly, it has a user engine. Hence, Brandstar does not qualify to be an expert. And whatever entity does not qualify to be an expert, its report cannot be qualified as an expert report, sir, simply. And hence, under CIAC Rules 29, as this claim is without any legal merit, because the sole foundation is without any legal merit and legal qualification, we surely do plead for an early dismissal of this application without even proceeding to the tribunal. Furthermore, sir, if you would Sure, sir. So if the claimant side is able to prove that Grandstar, the source of the sole foundation of its claim, is a legally qualified expert, is a legally fit and suitable expert. No, sir. Sir, with regards to 29 of the CI rules, a claim can be dismissed at an early basis, at a very preliminary basis, on two particular grounds. Firstly, if it lacks the jurisdiction, if it is proven that the tribunal lacks the jurisdiction, which I dealt with in my prior argument. And secondly, if the claim lacks a legal merit, prima facie per se. In this particular matter, sir, in this particular limb of the issue, it lacks a legal merit because the sole foundation of the report and the sole foundation of the claim is not legally bound, is not legally qualified. And hence, sir, we cannot rely on it to be legally qualified, which is why to save the tribunal's time as well as to save our time and to fast track the progression of the data supply, we treat this.
Are you implying that even Attenborough is qualified?
Yes, no, sir. Mr. David Attenborough in this particular regard is still not legally qualified because
saying that essentially the backing of David Attenborough's expert report, the concept is legally qualified. The AI report is not backed by the principles under IP or software.
So firstly, your clarification is that both the parties have not expressly agreed to the IBA rules. Hence, the only area for qualification that we can fall to is either the institutional rules or the governing law. With regards to the institutional rules, the CIAC rules are very silent upon the threshold for qualification of an expert. Whereas, with regards to Indian law, the general principles are contained under Section 45 of the Indian Ethics Act. Now, with regards to Dr. David Attenborough, Dr. David Attenborough's advice is squarely falling under any sort of role that an expert has to play, because the expert can only be of the assistance of the tribunal. Hence, for our case, apart from other foundations, such as we have surely and customarily complied with any sort of requirements that are progressed by the claimant, as would be elaborated by my colleague further. Secondly, the fact that we have in good faith also resent our data. Thirdly, we have made sure to tell them well in advance about the contours of this data, that yes, there are safety mechanisms which would trigger, I feel, misuse and go against the common industry practices of data integrity assurance, which will also be dealt by my colleague later. And fourthly, sir, just in a matter to rebut the AI systems report, Dr. David Attenborough's advice was sought. If we try to compare the reliability of both the sources, that is the AI report and Dr. David Attenborough's report, Dr. Attenborough's report surely trumps the AI report. If I may be allowed to explain on why. Sir, while AI systems in general are not defined as an expert anywhere, and they are not explicitly barred by law, we can surely refer to paragraph 28 of the Christian Logan Sass judgment from the Delhi High Court for our reference. If I may invite you to flag number 6, page number 47 of the compendium. So if you are with me. Panel, if we carefully examine this particular paragraph, paragraph 28, it talks about the contours in which AI is permitted to work at the given stage and day of age. I admit that we are living in the AI world, and surely it is an emerging industry standard. But even clarification number 3 that talks about it as an emerging industry standard, not an established industry standard. With regards to this particular paragraph, it is clearly denoted that AI can only be for a preliminary assistance to human experts and cannot substitute human experts. Hence, with regards to this particular judgment, and the soul and the reliability over Dr. Owing are more than transfer, if I may invite your attention to clarification number 5 of the procedure order 2, which talks about the prompt that has been commanded to transfer, on which it has released its report. The directions given by the master claimant. Yes. So, throughout this prompt, nowhere it is mentioned about the contours and the context of this particular paradigm. That it is a commercial expedition, it is the first in its industry expedition. All it has been stated is a kind of lesson. Sir, indeed, if we indeed, it was a pleasure.
Respected arbitrators, for the purpose of clarity before I begin, I would like to also highlight there was a time division between me and my co-counsel. I will be taking 21 minutes, after which I shall take a minute and a half for rebuttals, and my co-counsel shall then also take 21 minutes, and after that we shall take 1.5 minutes for rebuttals as well. With that, Mr. Arbitrators, I would like to begin with the submissions. Greetings, respected arbitrators, my dear colleagues. I am Pratyush Singh, and sitting before me is my co-counsel Jus Mundi, and together we represent the claimant Penguin Antarctic Adventures Private Limited. I shall be dealing with the first and second procedural issues, and my co-counsel shall then argue the remaining issues on merits. Members of the Tribunal, parties have entered into a data supply agreement to facilitate a safe Antarctic expedition. After receiving the data, the claimant wanted to check the accuracy of it and sent it to Brandstar, an AI system that has been considered an emerging industry standard. The claimant was then shocked and appalled when this report indicated that the data contained inaccuracies that would threaten the very safety and success of the expedition. As a result of this, the claimant has suffered significant losses, and it is currently seeking relief against those losses. On that note, Mr. Arbitrators, we seek 2 procedural reliefs. First, that the Tribunal declare it does have the jurisdiction to proceed without the pre-arbitral deposit, and that it should not make an order for security for costs. And secondly, respected arbitrators, that the Brandstar report is an expert report. For the purpose of clarity, my first issue has been divided into 2 broad limbs. I shall first be dealing with the pre-arbitral deposit, and my latter limb shall pertain to an order for security for costs. Proceeding with the first limb, the claimant submits that the Tribunal does have the jurisdiction to proceed without the pre-arbitral deposit, as a relevant clause is violative of public policy because it restricts the claimant's right to the access arbitration and is thereby invalid. Respected arbitrators, expressions like public policy and approach to public policy are incapable of a precise definition, and what constitutes an injury to public interest and public welfare depends upon the times and is open to judicial interpretation. Thereby, respected arbitrators, courts can, on consideration of public interest, refute a contract as it violates public policy. It has been held in the case of ICOM versus Punjab Water Supply that imposing a pre-arbitral deposit would discourage arbitration and it is contrary to the objectives of declogging the court system, and it would thereby be against public interest. Likewise, in the Canadian Supreme Court case of Uber versus Heller, the court held that the pre-arbitration clause would be void since it required an unjust monetary condition to initiate arbitration. Clause 45.2 of the Data Supply Agreement, respected arbitrators, also provides that parties bringing a claim forward must deposit 7.5% of the claim amount as pre-arbitral deposit. In our case, the quantum of this would be $3.75 million US dollars. And considering the claimant's financial health, such an unreasonable precondition restricts the claimant from even accessing arbitration and bringing forth its claim before the tribunal. Respected arbitrators, as established in the case of S.K. Jain that has been relied on by the respondents, it was said that the relevant pre-arbitral deposit clauses are in place to prevent frivolous claims. However, Mr. Arbitrators, while a claim may ultimately be found to be untenable, it need not be frivolous from the very get-go. And frivolous claims can later be compensated by imposing exemplary costs, and such a recourse is always available to the successful party. Additionally, it has been held that a pre-arbitration clause is without any nexus to the filing of a frivolous suit, as it applies indiscriminately to a suit frivolous or otherwise at the very threshold of arbitration. Due to this, respected arbitrators, the deposit is going to be made before any determination as to the frivolity has been decided on by the tribunal. Additionally, Mr. Arbitrators, and lastly in this court, it has been held that deterring arbitration to prevent a frivolous claim would be counterintuitive and is thus not justified. On the concern raised by the respected arbitrators as to the vagueness of the arbitral clause in the present dispute, I would make reference to the judgment of Lombardy Engineering versus Uttarakhand Jal Vidyut Nigam. It had been held herein that an ambiguous clause which does not indicate the disputed amount or the nature of adjustments would thereby be invalid. The claimant submits that the clause in question is also ambiguous as to the nature of adjustments that have been made. In the S.K. Jain judgment that has been relied on by the respondents, if a perusal is made through the arbitration clause therein, that is 25 case of clause 7, it has been specifically provided that this pre-arbitral deposit is going to be adjusted against the costs proportionately refunded. Respected arbitrators, this is in stark contrast to the case before us, wherein the only indication that it is a refundable deposit is one line that says it will be refunded after adjustment of cost. There is no indication as to how these adjustments are going to happen. There is no indication as to what is the proportion that the claimant is going to receive in the event its claim succeeds, or if its claim was to fail, and what would happen to the balance amounts. Respected arbitrator, this clause finds more similarities with the clause in the case of Lombardy, which effectively echoes the same sentiment that the party bringing forward a claim must deposit 7% of the claim amount as pre-arbitral deposit. The counsels for the petitioner in that matter argue that this clause, by virtue of being a security deposit, is inherently refundable, and thereby there exists no vagueness. However, the court, as the question was raised by Mr. President as well, the court therein held that this something which is open to understanding by the tribunal is this vagueness that makes it susceptible to being arbitrary. What has been called the silence of the clause in order to promote flexibility by my opposing counsel is actually the vagueness that is the doorway into arbitrariness. It is thus our submission.
I ask you, now about the vagueness of the clause. You were specifically directed, in fairness to counsel, to respond. You didn't take that point. You were specifically directed to the clause. Can you show us where in the record did you point out the vagueness of the clause, or any suggestion that you did not go by that after having of course accepted the contract and after the order?
Mr. Howard.
Totally private commercial contract. Concepts of Article 12, which were present in ICOM or in Lombardy, are exempt in this case because the other party is not a state. the primary party. So, one, you have not made any challenge as to the unconscionability or non-applicability of this clause. Two, in 11.6, when an objection is being raised, we are in article before tribunal, we are raising this objection and they are raising it. How do we accept it? Party autonomy will apply. I have to abide, and tribunal has to abide by no binding provisions of the contract. This is the law. I can't go beyond, I can't decide on the questions of equity. Equity considerations are out of date. Maybe a 1 year contract, how can I apply?
Yes, Mr. Arbitrator, I understand all the concerns that have been put before the council, and I shall take them up in a serial manner. Firstly, Mr. Arbitrator, pertaining to why we even entered the contract in the first place. It is not the claimant's submission that the DSA or even the pre-arbitral deposit clause is an unconscionable clause. However, we are placing reliance on the fact that the clause, by its very nature, remains violative of public policy. As to why we entered it, even though it is not a primary submission, the claimant inherently felt that it had no meaningful choice outside of the respondent. This is because it was not able to procure investments, and it was only entering a business relationship with the respondent that got in these much needed investments, and thereby not entering a business relationship with them was an existential threat to the very existence of the claimant's business. This lack of meaningful choice, which entails that a party can choose to abstain from contracting, led to a subsequent inequality of bargaining power. Mr. Arbitrators, it is our submission that when the claimant did try to negotiate on the price and the payment mechanism and requested for a discount, while the pretension was accepted by the respondent, they took away the 24/7 data integrity assurance. As a standard industry practice, this data integrity assurance was given to every client that they ever dealt with. However, the removal of something so seminal from the data they were supplying to us, which would ensure that it remained accurate and readable for a period of a year and a half later than the expectation would happen, took away from the commercial viability of our data. The claimant then understood that it was not in an equal negotiating path where it could go forward and put its interests forward before the other party and hope that they would be heard in their truest sense.
This clause was introduced prior to this data integrity change, or it was introduced later?
Mr. Arbitrator, this clause was introduced later, thereby the events that I am talking about have already transpired, and the claimant did not feel it was in a position to negotiate any further. Mr. Arbitrator, even though there has not been an overt act of duress or exploitation, a weaker party feels just as out of negotiating power, even if it is an inadvertent inequality in bargaining power. It is for this reason that the relevant clause was entered. Pertaining to the contention of Mr. President as to how we can apply the precedents of Lombardy and ICOP in the present case, seeing as these are not government parties, it remains true that the claimant is not submitting to the clause invalid on grounds of Article 14. It is only being submitted by the other part of the ratio in the cases I talked about, restricting and discouraging a party from arbitration, thereby becoming a public policy concern, is what the claimant is contending. Respected arbitrators, it has been held that public policy concerns are a reasonable restriction on the exercise of party autonomy, and every party has the inalienable right to seek judicial recourse, and this cannot be taken away even with the concurrent will of the parties. The tribunal thus still reserves jurisdiction, and the claimant is not wrong in bringing forward this claim at this point of time. Additionally, Rule 28.2 of the SCR rules provide that the tribunal has the power to rule on any objection pertaining to the arbitration agreement. And the claimant, while it did make an oversight in the past, is now not erroneous in bringing forward this claim before the tribunal. Mr. Arbitrator, if I've answered all of your questions.
I want to ask you the same question I asked your opposing member, which is to say, how do you read the clause as being security for what purpose exactly? Is it plain cost or something else?
Mr. Arbitrator, seeing as how our responding counsel has relied on the SKJ judgment, the claimant understands that this security deposit would be taken from us in order to ensure that firstly, our claim is not frivolous. However, this contention does not stand. In the case of the SKJ versus the state of Haryana, this security deposit would be subsequently used to adjust costs, which is also a stipulation that has been presented in the data supply agreement. We thus understand that as far as has been explicitly discussed between the parties, this is only in order to assuage the legal costs between the parties. Is that answer?
And it's your position that your financial health is a factor in our determination of whether this clause is violating the public policy or not?
Yes, Mr. Arbitrator, the claimant agitates before this tribunal that it is not in a position to satisfy such a pre-arbitral deposit, precluding it from accessing arbitration, whether it has a prima facie claim, or the fact that it cannot access it would be a miscarriage of justice, and it remains the claimant's intention to continue this submission before us.
Now, my question is that isn't that very much the reason why it's important to have the security because if your financial health is poor, as you say so, then that's all the more reason for concern for the respondent because they are worried that any cost of what that they succeed in achieving, if they win the case, is not something they can enforce against you if you don't have the money. And that's the reason the cost exists in the first place, as you rightly said.
And the second question, that financial viability has nothing to do with the public policy. Either clause is asking them to deposit before going to arbitration, or is asking you to go to arbitration without deposit, or restricting the right access to the arbitral proceedings. So, how do you justify your taking this question of public policy with the financial needs?
Mr. Arbitrator, to answer Mr. Pesting's question first, as I would conclude my previous submission, it is the claimant's submission that the public policy contention that we bring before this tribunal is that arbitration as an ABI mechanism has to be encouraged and parties should not be discouraged from accessing the same. That the financial health of the claimant is going to preclude them from actually fulfilling the pre-arbitral deposit is merely a factual scenario that we would like to present before the tribunal so that they can better understand and move forward in the goals of equity and justice. It is not a submission that merely because the claimant is in poor financial health, this clause should be read out of the contract. And we continue to place reliance on the public policy concern that was raised in both ICOM and Lombardi judgments. Yes, Mr. Arbitrator, it remains the claimant's submission that the clause should be fully declared to be invalid. Moving on to Mr. Arbitrator's question, that effectively brings me to my second limb of argumentation, which I shall answer in effectively three blocks. Firstly, Mr. Arbitrator, the respondent had agreed to arbitrate with an impecunious party and had consented to the business risk. At the time of entering into the contract, the respondent was aware that the claimant was a capital-intensive startup, that it had had troubles procuring investments, and that a significant chunk of its investments were contingent on the successful completion of the expedition. They had thus consented to this and knew that the claimant was not at that time in a financial position to enter into such heavy costs and make such assurance that it could fulfill heavy costs in the future. The position of the claimant has not changed since then, and seen as how they had consented to this business risk and agreed at that point to arbitrate with an impecunious party, they cannot now raise a concern that merely because the claimant might fail to fulfill an adverse cost, they should be entitled to receiving security. This brings me, Mr. Arab.
They were aware that what you can do is that is debatable. Is to say that's forbidden cost because you are probably something which is not flush with money. Let me create some security for myself to say that if you want to bring a claim in the future, at least there's a requirement for deposit. So that's how they did. So it's not to say that they ignore the fact or came from the fact or very happy with the fact. They did so that in the contract. Why should we ignore them?
Mr. Arbitrator, this would bring me to my next submission. That mere financial hardship is not reason enough to make a security for cost order. It was held in the case of Arts and Production Corporation versus the government of Grenada that the threshold to make an order for security for cost is very high, and the requesting party would have to establish more than mere financial difficulties. It is then submitted in our second limb of this argument that the claimant does not face any irreparable harm if the security for cost order was not paid. This is because the assets of the claimant are readily available in Bhopal and can be then used to satisfy any adverse cost award that would be decided upon by this tribunal were the claim to fail. Respected arbitrators, the respondents were acutely aware of this, and it is for this specific reason that the legal team decided to keep the sealed venue and the governing law be in India. If I could draw your attention to Exhibit R2 on page number 28, Mr. Arbitrators. If the arbitrators are with me, I should read out the last interrelevant clauses. Given that the claimant was a startup, we were apprehensive about the balance payments coming on time and wanted easier enforcement. I remember the legal had saying, let us keep everything in mind. This shows us two conclusions, Mr. Arbitrators. Firstly, that they were aware of the business risk that they were taking by entering into a contract with the claimant. Secondly, Mr. Arbitrators, that they did want to make an easier enforcement for a security purpose order, considering that the assets of the claimant are available in Bhopal. It can thus not be said that they would face any irreparable harm, and the balance of convenience lies in favor of the claimant. It is for these reasons that the claimant raised before this tribunal that it should not make an order for security purposes. If the tribunal does not have any further questions, I should like to move on to my second issue. Mr. Arbitrator, I see that I am nearing the end of my time. If I could have an extension to conclude, and certainly, Mr. Arbitrator. For the purpose, Mr. Arbitrators, at the outset, I would like to prove to you that the brand staff report does have evidentiary value. And I apologize in advance for the page flipping I'm about to take you through. If I could direct the tribunal's attention to Exhibit R1 on page number 27. If the arbitrators are with me. Here, in paragraph 4, line 2, Professor Attenborough admits to the presence of minor inaccuracies and discrepancies. In that same paragraph, Professor Attenborough states, and I quote, that the inaccuracies identified do not pose an insurmountable challenge to safety. Likewise, in paragraph 2, line 2, Professor Attenborough states that these discrepancies do not pose a significant threat to the safety and success of the expedition. Respected arbitrators, not posing a significant threat is not the same as not posing a threat at all. That the inaccuracies identified do not pose an insurmountable challenge indicates that there does exist a degree of risk that Professor Attenborough is aware of and then goes on to assume are surmountable and can be overcome by the claimant. We thus submit, Mr. Arbitrators, that Professor Attenborough reaches two conclusions. Firstly, that the data supplied does contain some inaccuracies and that these inaccuracies resultantly pose some degree of challenge and risk to the safety and success of the expedition. If I could now direct the tribunal's attention to Exhibit C8 on page number 22. The arbitrators are with me. Here, the brand staff report also makes two conclusions. The first being that the data is inaccurate, and the second being that relying on such data would endanger the safety of the expedition. Respected arbitrators, there is thus no technical discrepancy between the brand staff report and the report submitted by Professor Attenborough as to the presence of firstly inaccuracies and secondly challenges to the expedition. We thus submit that brand staff has produced an accurate result which has subsequently, or albeit indirectly, been corroborated by a human expert. Respected arbitrators, the obligation of an expert entails that they fulfill the technical lacuna in the understanding of the tribunal. The brand staff has operated with the same technical acumen as Professor Attenborough speaks to its credit and ensures that it must be adduced as an expert. To answer the obvious question that arises here, Mr. Arbitrators, the conclusions of the report are vastly different. Professor Attenborough states that the successful expedition can be executed by the claimant and recommends that we go forward on this. However, Mr. Arbitrators, to this our submission is Professor Attenborough is not an expert on the contract executed between the claimant and the respondent. He is not in a position to accurately comment on what was the intent of parties at the time of entering into the DSA, what were the contractual representations and the subsequent obligations of the parties, whether or not such inaccuracies or minor challenges were permissible at all. It then becomes important, respected arbitrators, that this be adjudged solely on the basis of merits, which, as my merits people shall further substantiate before you, indicated evidently that the claimant had placed complete reliance on the respondent for 100% accurate data, and derogation from this.
Question before the panel is not whether Mr. Attenborough is a suitable expert, or whether he is a good expert or a bad expert, or whether his report is correct. The only question before the panel is whether brand staff and the report that you have filed is something that the panel should even consider.
I think by the way, the focus of your submission should really not be so much on that. Focus on the admissibility of the brand staff. It doctors on that.
Certainly, Mr. Arbitrator.
AI.
Yes, Mr. Arbitrator, certainly. The reason that we were placing the reliance on the Professor Attenborough report was for one primary reason. that the respondent has admitted to the conclusions of the brand staff report. While we agree that the standard industry practice around the usage of brand staff entails that it is verified by a human expert, and that this was a step that was mistakenly omitted by the claimant, the respondent has gone forward and admitted to the very conclusions that are stipulated in the brand staff report.
That's 3 steps down path, right? Because that's on the question of the merits and whether the respondent's expert is in agreement with the basis, conclusions, findings is something that we consider as part of the merits. The question really is, do we look at this piece of case or not?
Certainly, Mr. Arbitrator. Certainly, Mr. Arbitrator. To this, our submission remains that it is a mandating principle of international or arbitration in general that parties have the right to present their case before the tribunal. This mandatory right entails that parties also have the right to present any relevant evidence before the tribunal for its consideration, whereby the tribunal can then decide on the reliability and weight it wants to place on such report.
Question. Information may be very relevant, very particular, but it may not be accessible, like a confession given by a specific. So here as I understand, information on the other side is that it is not admissible at all, because firstly it cannot be treated as expert. Secondly, there the fundamental principle of using material to be taken as a material in terms of reliable proof evidence. That opportunity is losing from them. They cannot cross-examine their AI. So how do we treat that material as an admissible material at the threshold? Will you please elaborate it?
Certainly, Mr. Arbitrator. It is our submission that brand staff is a much obliged, Mr. Arbitrator. It is our submission that brand staff is a reinforcement learning AI system. These are trained to navigate complex environments and work on a risk-reward system. Brand staff was fed in the data and was given a simple prompt: see whether the data is accurate and whether or not a successful expedition can be executed based on this. Brand staff, as a reinforcement learning system, has, as I mentioned before, a risk-reward system, and it emulates the models therein. Mr. Arbitrator, the claimant's position is that brand staff is an expert report which should be relied on.
Please answer this question on the basis of its
Certainly, Mr. Arbitrator. Yes, Mr. Arbitrator. As has been established before, the only obligation of an expert that has been listed out in the CIAC rules, not listed out in the CIAC rules, but has been indicated in the CIAC rules and has been codified in the IPA guidelines, which although not binding do establish best practices in taking of evidence, is that an expert should fulfill a technical lacuna in the understanding of the treaty. If brand staff is able to fulfill and give you this technical expertise, respected arbitrators, it is our submission that it fulfills the requisite of an expert report. And the second aspect of this, Mr. Arbitrators, excluding relevant testimony that might preclude a party from bringing forward its most relevant and material evidence would be a violation of that the expert report has been included under the ambit of evidence in the IPA guidelines.
And the evidence which is not admissible, tribunal will be definitely in within its jurisdiction to reject that.
Mr. Arbitrator, I have 30 seconds to wrap up my last point. Thank you, Mr. Arbitrator. It was a pleasure arguing before this tribunal and we remain okay.
Sir, I would very briefly point out what 10 major rebuttals to the claimant's speech.
I don't think you have time for that, but if you get your top 5.
Fair, sir.
Yeah, I mean, what it is, you think you can capture the attention of the tribunal on 10 rebuttal points in 90 seconds? Choose carefully.
I can't help but
So
my
make it-
friend's speech was very fallacious.
Make it hard 90 seconds.
So how much time is left for the 1.5 for 90 seconds?
I'll try to balance this. So, to start things first, Rule 29.2 of the CIAC rules, just to clarify, when an early dismissal has been called for, we need to align with both the facts as well as the legal merits, which is why a legal foundation for the claimant's claim has to be denoted even at the level of preliminary objections. So where does this legal obligation comes from? Section 145 of the Indian Evidence Act, although not directly applicable, but its general principles do applicable with regards to cross-examination specific, as also raised by the tribunal. As Branstock is an intangible entity which cannot be produced before the tribunal, it cannot be cross-examined or corroborated. Thirdly, sir, the claimant won't be able to get investments and hence they came to us. This was not the reason as entailed in Exhibit C1 of the case record, sir, because they were very heaps and praises for our company being unique and being potent enough to carry on their expedition. Them being helpless was never known to us, and now that they realize that they are in a financial impecunity, if they say that they committed an oversight earlier and now they have to rectify it, this is not the stage for rectification, this is the stage for execution of the final draft. Further, sir, when we talk about as to how the respondent consented to agree even though we are impecunious, so is it our fault that they are impecunious at this particular point of stage? First of all, they're not impecunious at all. If I may invite your attention to clarification number 20, a whole table has been given with regards to their income and expenditure division, wherein apart from $17.5 million, which is contingent investment on the basis of success, the rest of the investments are still there with them. If I may just conclude in 20 more seconds, sir. Much obliged. Further, since minor inaccuracies are not challenged, it is a hypothetical research. It is first in its kind research. There would be minor inaccuracies. However, what is challenged is whether the DSA can be safely complied with, which is what Professor Attenborough said. And if my learned friend contends that Dr. Attenborough was unaware of the contours of the contract, so was Branstock. Branstock was even unaware of the contours that it is a first in its kind commercial expedition. Hence, when Branstock submitted its data, myopic only aware to the respondent's data as well as public sources, Dr. Attenborough's report turns out to be much more clear. Thanks for bearing this.
Respected arbitrators, if I could be afforded the chance to counter the balance points and 20% consideration. Mr. Arbitrator, outright. On the matter of cross-examination of Branstock, in international arbitration, methods like cross-examination or witness conferencing or hot tubbing of expert witnesses is done only to discern the areas of disagreement between the parties. The claimant, as established before, maintains that there is no area of technical disparity between the parties. Further cross-examination would achieve little except reiterating what has already been stated and admitted to by the respondent. And any fact that has been admitted to does not need to be further proved by the claimant. The tribunal can thus exercise its powers to determine the procedure of the hearing and forego the rigid procedural requirement of cross-examination in the interest of expeditious and economic resolution of the dispute at hand. Mr. Arbitrator, on the matter of whether or not the impecuniosity of the claimant is the fault of the respondent, the claimant does not allege that the relevant situation has happened because of the respondent. However, they were aware of our financial health at the time of entering into the DSA, and there has been no material change in this circumstance. They cannot thus now wash their hands off and say that we were not aware, which is why we now demand security, especially when they had factored in this impecunious nature of the claimant and then decided to keep the arbitration in India. On the matter of minor inaccuracies, lastly, Mr. Arbitrators, they had talked about how it is a novel area. Two counters to this. Firstly, Jus is an expert in providing data, and data is not something that is contingent on the specific narrow expedition or the channel that is being used by the parties. If I could have a brief explanation. Thank you, Mr. Arbitrator. Additionally, Mr. Arbitrators, on the matter, I'm so sorry, Mr. Arbitrator. Oh, I'm so sorry, Mr. Arbitrator. I heard. Certainly, Mr. Arbitrator. Minor inaccuracies, while characteristic of every data set, have been accommodated by the Branstock system. This is because 15 data points were supplied by the respondent, but Branstock only flagged 2 of them as being serious enough to pose a threat to the safety of the expedition. They can thus not claim that it is the characteristic nature of data to have these inaccuracies and that the claimant cannot rely on these to call the data non-conforming and effective. It was an honor arguing before this tribunal. I'm really sorry for overstepping my time limit. Mr. Arbitrator.
Good afternoon, arbitrators. Am I audible? If I may make an Greetings, respected arbitrators. As introduced by my co-counsel, I am Jus R.K, and I will be taking 21 minutes of this tribunal's time to deal with the merits of the case on behalf of the plaintiff. I will be addressing the third and fourth issue of our case, for which I submit that third, the DSA or the Data Supply Agreement is governed by CISG, and fourth, that the goods supplied by the respondent are defective and non-conforming under it. Respected arbitrators, for the purpose of clarity, I have divided my third issue into two broad limbs. First, I will establish that CISG can apply to the DSA signed between the parties. Secondly, I will establish that data can be seen as a subject of a contract under CISG. Moving to my first limb, respected arbitrators, that CISG Respected arbitrator, coming to Mr. Preston, coming to a primary concern about ownership, and how you talk about people can sell it to other parties and that it should not be seen as ownership. It's important to look at the intention of the parties here, respected arbitrator. The intention of the parties was not to sell it to anyone else and not to use it for any purpose other than what it was meant to be used.
So therefore the rights are restricted.
Respected.
You're saying the rights are completely transferred. I don't mean the once I have transferred something to another person. I can even know someone sell it. I'm not telling that which all contracts he has to put in or which he cannot. Or which he can do, which he cannot. So when you transfer something, you transfer you don't have any further control. Here they are telling you that you will utilize, you will restore a part place, you will utilize for a specific purpose. How to overcome that aspect?
Respected arbitrator, here we submit that we are not restricted or limited by this, but this is simply all we wanted, which is to say it's important to look at what the purpose of the contract was and what the data can be used for. Because I cannot make profits by selling this data because this expedition is unique to only me and my client itself. Additionally, the contract was agreed upon by both parties even in terms of the confidentiality agreement, which is to say that we had no problems with keeping it in one, which is to say that we had no problems in not sharing it with any other party, and for our intents and purposes as well, we would be fine in this sort of agreement, which gives us in effect complete ownership regarding our intention of the contract. So there is a transfer of property in this matter. Proceeding, respected arbitrator, we then submit that additionally in this limb, respected arbitrator, Article 2 of CISG gives you an exhaustive list of what is excluded from the ambit of CISG. The intention of the drafters was this: we don't give a definition to good, but we give an exhaustive list of what cannot come inside this good. Data does not fall under this definition as well, which wraps as a submission that data be seen as a good. Next, respected arbitrator, we move on to why this should be seen as a sales contract. And if I can bring your attention to Article 3 of CISG over here, we would have that in the compendium page 128, but I will read it for the sake of convenience. Article 3.1, which we rely on, contracts for supply of goods to be manufactured or produced are to be considered sales unless the party who orders the good undertakes to supply a substantial part of the materials necessary for such manufacture or production. Respected arbitrators, the submission then is this. This is a contract for supply of data to be produced by the respondent party, and that is exactly what happened. The additional burden we have to prove over here that we didn't provide them a substantial amount of materials necessary for this provision, and we rely on two case laws for that, which hold first, that specifications are not said to constitute a substantial part of the materials necessary, and secondly, it is immaterial whether the goods are customized or not, and they don't hold to be a substantial part of the materials necessary. All we had provided them was specifications for this data, and they have produced the requisite goods, and this is seen as a contract for sales under Article 3.1 of CISG. Article 3.2 of CISG might be contended by the respondents comes into play, wherein they try to say this is a contract of service, and service is the preponderant obligation in this case. But understanding of Article 3.1 of CISG is that
if there exists supply of labor or services in order to produce the good in question, this labor or service is said to be immaterial. Which is to say that if I had to craft the tables the president and arbitrators were sitting on, and I spend my labor and service in producing this table, it is immaterial because at the end of the day, it is a contract for supply of the table in question. Then the services become immaterial in our present case. If there exists no further questions, respected arbitrators, we also understand one final part of this link, that the preponderant part of this is generation of data points, which is done by the claimant, which is done by the respondent. Because if it was just compilation of resources, if it was just compilation of data, they could have got to anyone else. But they came to us because we generate new data points by analyzing data, and these are our non-public sources, which this service becomes the preponderant part of our application. Respected arbitrators, something which the respondent does is they compile data points, they analyze these data points and generate newer data points. And these data points are exclusive to them and are non-public sources, which is the reason the claimant went to them for the DSA, because there exist these special data points. So the preponderant part of this obligation, which is the main weight of this contract, has been placed on their service. This act. Respondent. My apologies. My apologies, Mr. Arbitrator. Our point here is this: the preponderant obligation is a service of the compilation, generation of new data points in the analysis done by the respondent, and thus it's a service contract, thus it should not be seen as a service contract. Respected arbitrators, that is not by submission. We submit over here that they might contend that this is a preponderant part, but this should not be seen as the preponderant part, because labor and service in production of something is said to be immaterial. The same example I gave you of the construction of the table, respected arbitrators, it came off wrongly with the submission versus this, that if they
this is Kavni Kaur from the side of respondent. I'm giving you minutes today. You may start my time in 3, 2, 1. Thank you. Before proceeding with the submission of merits, it is really important to we understand with what concerns that we come forth to this tribunal today, and what exactly has been our major concerns as we come. Members of the tribunal, the claimant has relied on our data that we send them, and they have announced the date of their expedition, subsequent to which they contend that the same data that we send them, based on which the expedition was announced, is defective and non-conforming to the representations and warranties, particularly the ESG compliance as well as the accuracy. In light of this background, members, today I shall be making 2 submissions. Firstly, that CISG is not the law governing the data supply agreement of the DSA. And secondly, in arguendo, even if CISG is, then the goods, that is the data that we supply, is conforming to all the representations and warranties. Starting with the very first submission, I would divide my first submission with regards to the applicability of CISG into 2 prongs. The very first prong shall talk about the imperative thresholds with regards to the applicability, and the second prong will be talking about the preponderance, which my opposing counsel just stated. With regards to the threshold, Mr. Arbitrator, if I may be allowed to make one single statement or observation. Much of it, not an issue. Not an issue, definitely, Mr. Arbitrator. With regards to the very first submission, whether data is qualifying to be goods in the current transaction or not. Mr. Arbitrator, when we are talking about the definition of goods, which is correctly stated by my opposing counsel, is not provided in the convention. But the CISG, that they should be movability and I would just like to talk about a very famous German court case, which is the market research study case. Now, if I may be allowed to peruse the facts of this case very briefly, and if I may be allowed to quote, essentially what exactly happened in this case was that the plaintiff in that case was required to send a market research analysis to the defendant. Owing to certain disagreements between both the parties, they went to court contending that we will not pay, which is not our concern right now. But what the court addressed, which is of our concern right now, is that whether such market research analysis is essentially qualifying to be goods, just so that CISG could be drawn. Now, when we are talking about whether CISG can be drawn in such delivery of market research analysis, the court held, and I quote, which is also provided in the complaint, but if I may be allowed to quote here, noting that the sale of goods is characterized by the transfer of property in an object. The court found that although a report is fixed on a piece of paper, the main concern of the parties is not the handing over of the paper, but the transfer of the right to use the ideas written down in such paper. Therefore, the court held that the agreement to prepare a market analysis is not a sale of goods. What exactly is the observation that the counsel is trying to draw here is that similarly in the current case, there was supply of such information which is being done from the respondent side to the claimant side. If I deal with this aspect in two links regarding separating the report and the supply of data which we did to the claimant right now, the report can very well not qualify to be a sale of goods in the current transaction. Even if we deal aspect of data, Mr. Arbitrator, then that essentially is mere information which is being supplied from the side of respondent to claimant. Now, subsequently, a question of supply of information, can it be a specific sale even if it's not qualifying to be goods in the current transaction? Which will bring me to my next submission, whether such supply of information is qualifying to be sale or not. For the sake of brevity, Mr. Arbitrator, the merry-go-round case of the Italian District Court stated two imperative requirements which will qualify a transaction to be a sales transaction. Number one, a permanent transfer of ownership, and number two, delivery of goods. Now, if we address these two characteristics with respect to the current correspondence and see whether there has been a permanent transfer of ownership or not, then first of all, my learned friend talked about how when they download the data, they get permanency attached. But Mr. Arbitrator, the idea underlying such permanency of ownership is the exclusive use to such information that they have derived, which will conclude whether there actually is a sale happening. Do they have the exclusive use to such data which they have downloaded which they claim is permanent? They do not. Given the fact that at any given stage they wish to copy the data, use it at any other system, use it in any other format, they have to come to the respondents and ask for their permission to copy such data, given the fact that the decryption key is available only to the respondent. Therefore, the aspect of permanent transfer of ownership with regards to exclusive use of data in the current transaction stands to be blemished.
How do you explain? According to you, you say that it is given on a particular pen drive, therefore it is not a transfer of ownership. Suppose someone goes and buys some Swiss and he gives it. Is it not a sale? Somebody transfer of ownership?
Indeed, Mr. Arbitrator. Now, to address that concern, what the counsel is first of all trying to say over here is that when we supply the data from our side through a SharePoint link, which is an intangible medium of supply, then in that transaction they contend that they received the permanent ownership. But when you receive the permanent ownership, meaning if I define ownership in very simpler terms, you get the right to alienate it. You get the right to use it as in how you wish to. You get the right to reduce it, to recycle it as in how you wish to. In the current transaction, Mr. Arbitrator, when they are talking about such permanency of ownership, they are not getting the exclusive right to use it as in how they wish to. Agreed, they might say that the data is of a specific format, but it is also noted that the data is specifically designed such that their systems can match that data.
Is your contract saying that you will be able to others for the data which you are supplying?
No, Mr. Arbitrator, it is not explicitly stated.
So there there's something to transfer the entire ownership, and as far as encrypted, it will not be a physical thing to be to amount to a sale of goods. Today, we
Mr. Arbitrator, to address the concerns which I completely agree are very relevant to the current case. I shall answer in let's say three prompts, just so that it is more clear. First of all, continuing my answer, Mr. Arbitrator, the case explicitly is not saying that we have retained ownership, but that exactly is what is happening in the current transaction. We have the ownership and we've merely given them the right to use the information which we provided them. Coming over to the second part with regards to what exactly do we mean when we say that we are implying or sending this right to them so that they can use this information for a stretch of time period, which I completely agree. Now, Mr. Arbitrator, clarification summary is clearly talking about them supplying to us certain samples and observations, as per which our data was to comply to those samples and observations which they sent to us. In light of that, we send them the SharePoint link on which data or the information which was there on that SharePoint link was to be downloaded within 7 days. Once they did that, the data could be accessed by them. Now the next step that arises is whether they can reuse the data multiple number of times. They can, provided they do it on the very same system as per which the data was designed. Given the fact that they themselves specified what exactly will be the design of the system that they shall be using the data, it is clearly evident from the very reasoning that they themselves told us what exactly will be the purpose of the data that they will be sending them. We gave them the right to use the data as and how they want to, provided they are. If I may please continue, sir? Continuing with the very same fact, sir, after which I shall also be talking about my submission, they have the right to use that information within the very restrictive ambit which we provided them. This restrictive ambit was also guided by this fact that this restrictive ambit was also guided by the fact that they themselves complied to abide by this restrictive ambit. Moreover, when they are talking about how we omitted giving them the 24/7 security, which we usually give as per our norms, then they themselves consented to it. They themselves talked about how they wanted the discount, and when we showed that this could be one way through which the discount can be obtained, they agreed. In light of that, Mr. Arbitrator, though the entire proposition might not be explicitly talking about us retaining our ownership, we have merely given them the right to use this information within a very restricted ambit. If I may be allowed to proceed to the second prompt, Mr. Arbitrator.
Just one question, Patrick. Given the agreement that is seated in Bharat, is there any law from Bharat or India, maybe a question of whether data is good, whether it's qualified as good, is there anything that writes this agreement? Because we seated in Bharat, we are bound by the law that applies here.
Indeed, to answer that very specifically, without even taking to any specific legislation, we can talk about the TCS case, which is the Tata Service cases versus Andhra Pradesh, in which this very imperative question came forward as to whether software is qualifying to be goods, considering that in that case it was specifically for the purposes of taxation, which is not right now, but we still can discuss whether that reasoning can be a guiding principle for us or not. Now, Mr. Arbitrator, that reasoning very well brings me to the very second prong which I shall be discussing with regards to applicability of CISG as well.
I'm sorry, you didn't
No, sir, I'll answer that. Yes, sir, indeed, sir. In that case also, sir, they considered canned software, which is standard software, to be capable of drawing the aspect of that. It was considered to be safe, particularly in that transaction, given the fact that specific to that case, the sale was made through a CD or a floppy disk. So they held that such supply of canned software will qualify to be goods. However, the case also made a very small observation that when there is unclaimed software, which is not specifically defined anywhere but in the case as well, the small observation was made, which is basically custom-made software. In that case, whether the sale aspect will be applicable or not is something which is still not settled. They did not explicitly deny that it will not be applied, but they did not also say that the settled position is that sale will be applied, which the council completely agrees. Now, to address that aspect, in light of CISG only members, I will be talking about the second prong of applicability of CISG, which my learned friend made a very important observation as well, with regards to preponderant obligations. Now, members, if I straight away jump to Article 3, Clause 2, which is kindly be allowed to read, much obliged. Article 3 Clause 2 states, this convention does not apply to contracts in which the preponderant part of the obligations of the party who furnishes the goods consists in the supply of labor or other services. Now, a very important, before proceeding with regards to what exactly this means, the aspect is of goods in the current transaction. Now, a very small clarification, members, I am still not agreeing that data qualifies to be goods. However, for the sake of explaining this stance, even if we do agree that data is goods, observations are made, the current supply of data in the by this preponderant obligation of service which the respondent is furnishing. Now, before proceeding to the exact exhibits and exact statements in the case record, let us just take note of this fact as to why the claimant came to respondent for the supply of data. They very well had their own data systems which could talk about what exactly is the date through which the expedition could be announced, which they themselves have agreed to in the clarifications. They came to us because they knew we had expertise in this, meaning that we could provide accurate data. So they did not solely rely on us for the data points that we were supplying, but on the expertise, on the knowledge as well as the experience which we would be providing them. To make it even simpler, members, if I may please draw your attention to page number 6, paragraph 3 of the case record. If you will with me. If you with me, members. If I may be allowed to please read it out. It reads out, Zeus is in the business of supplying exclusive data about air pressure, weather forecast and other climatic conditions, which help assess the optimum date and time for extreme tourism. The data is compiled from several places and includes analysis of all data points related to all crashes and successful expeditions known to mankind. The reason they came to us is because we provide an analysis of all such expeditions which are known to mankind in this. This aspect is the service which is being provided. Now, I know questions arise as to how I am deriving this to be a preponderant obligation. For that, we can rely on the test of preponderance. Now, CISG Advisory Council number 4, which specifically is the commentary dealing with Article 3, talks about 2 imperative tests, and I shall rely on one of them, the essentials criterion test. If any sort of service is being supplied in the form of a data supply, in the form of any contract, is so essential to the entire contract that the entire contract is dependent on that service will qualify to be a preponderant service, which is the essential criterion test. Now, I know questions arise as to, like for example, if I may even take an example of, there might be circumstances when such services may be relied by different people and this still is not qualified to be a service contract. Members, we still need to take into consideration that the current contract is a supply of intangible goods on an intangible medium, which is the reason that when we are supplying services in the current transaction, we are supplying those services with a preponderant obligation to them. I have multiple more instances wherein they do not just ask for raw data points from us, but also analysis of those raw data points. Given the fact that the report that we are submitting itself is a full-on analysis that we are making with regards to our own knowledge and expertise as a service, yet the data that is the primary governing factor of the entire DSA is something which is a preponderant obligation of services that the respondent are getting them. If members allow me to move to
in a given case, you would have expertise and everything else, but I only know how to sketch up a painting. I do like, and then I sell that painting to the other side. Whether it is a sale of goods or it is a sale of services.
Indeed, Mr. Arbitrator. Very well concerned that you raised. In that light, we need to look at the current factual circumstances with regards to your question. Now, when you are selling a painting, Mr. Arbitrator, the idea that the council is drawing here is the expertise that you have in that painting. Now, to elaborate on your example and take it as the example to explain it, let's say a kid of 5-year-old is making a painting and selling it. And at the same time, probably Vincent van Gogh comes and he paints a sketch and is asking to sell it as well. Which will be sold more, considering the fact that right now that aspect, given the fact that the painting in itself is a good which is being sold on a tangible medium. But let's say that they are using their respective art of painting for furnishing some other sort of service. Now, Mr. Arbitrator, in that light, the service which is being provided. Indeed. Indeed. So, the idea is that when you're providing services as an expert company in the current transaction, that service is being a preponderant obligation, which is the fact because the claimant was well established enough and they could themselves talk about these raw data points which they themselves agreed upon.
I'll give you another example. I'm very good in analytical methodology, how to see procedural Supreme Court. I create a software, I give input, I put understanding practice in Supreme Court. And then I sell it to, say, Pro, Deal or any other, or license it for, to be fair, license it to another company. Whether I am selling the goods or I am giving my services. Because you have to answer this question, that distinction we are trying to understand.
Indeed.
Because here preponderance is my expertise, my services, my understanding. But ultimately what I am transferring to him is the data which is the product of my understanding and ability. So that data is goods or services.
Indeed, sir. Now in the current transaction, given that you have the expertise of producing the data that you did as a software which is being supplied to the other party, now the idea is why that other party approached to you for that data as well, which in the current transaction is playing a very important role. Now, if the other party approached to you because you have that expertise and is the reason why they're taking that data point, then your service is the one which is being the preponderant aspect. However, if the same is made as an open-ended, basically you would just like some other market player in the market, and the buyer just comes to you and asks for the report or for any other thing, that is a separate concept. The important factor that comes to play right here is the reason why they're coming to us. The idea is that we are not just supplying to them raw data points which they definitely can find from some other people, but we are supplying with those services which are the preponderant obligation, also the services on which we are taking so much money from them. That service is being the preponderant obligation, qualifying to be essential in the entire data supply agreement. And that is the reason this service cannot be talked as a good in the current transaction. If I may be given some time to talk about issue 4, members. Much obliged.
Because now they have got lesser time.
Indeed. Actually, just summarizing the entire thing on 3 different prongs. The very first, on the very face of it, before talking about the other 2 prongs, the test of conformity, the idea is that the entire data supply agreement was terminated on the mere suspicion of non-conformity members. The expedition has not taken place. Their basis on brand staff has not been proven. Yet they have gone ahead and they have terminated the entire data supply agreement on a mere suspicion that, oh, the data might be non-conforming. In light of that, if I talk about the Orbit versus Betemo judgment as well, members, a single line ratio in that judgment talks about when an alleged defect is being talked about by the buyer, they need to provide evidence to substantiate that defect. In light of that, this entire termination is a mere suspicion. Talking about the 2 prongs together, coupled as the test of conformity. Article 35 Clause 2 Part A talks about the ordinary purpose test and Part B talks about the particular purpose test. Now, members, how the current 2 tests are being qualified in the current transaction are 3. First of all, they made us known the purpose for which they are wanting the data, to which we complied. Number 2, when the particular purpose test is specifically being talked about, whether we comply with the particular purpose test in the way that they wanted us, as in the specifications which were implicit as well as explicit in the contract, whether those were abided by or not. And thirdly, whether as a respondent we are supplying goods that are in general conforming to the quality, quantity and description. Very lastly, members, if I talk about the ordinary purpose test, it was to undertake an expedition which was timely. We supplied the data on December 27. Resupplied the data as per their own allegations, despite the fact that their chief engineer was the one because of whom the data was corrupted. Yet we supplied the data. Yet we supplied the data timely. For the particular purpose test, members, when I'm talking about the first mover advantage, and the compliance to ESG norms. These were the particular purposes for which they required the data. Supplying accurate data and supplying data which was within the time frame that they wanted. They could very well have data which was compliant to ESG. And if members allow me to move to the prayer as well.
That's all right. We have your documents.
Much obliged. It was a pleasure, RK.
May I proceed? Thank you for the analogy, Mr. President. We will bring you to page 59 of our compendium if you could, and that talks about the exact same analogy. A small preface before that, we submitted Article 3.1, a contract for supply of goods to be produced. They talked about it as a mixed contract of services and services and supply. I'll read the paragraph 19 of page 59. The work necessary for production and packaging of goods cannot be considered a service in the sense of 3.2 CISG, as otherwise 3.1 would be a meaningless provision, which means everything you talked about, all the services, experience, knowledge, everything is perfect, but it's being used to produce a good which is being supplied. This is a contract for supply of good. Article 3.2 doesn't hold good. All the experience, knowledge they have translates into the good which they supply, and that is the contract which it's talking about. Secondly, if I can bring your attention to page 15 of the case record, the line just says our fee for the data points is $5 million. And in page 10, services, not the report, those are ancillary services. Coming.
One that you do not specify that what amount is required to be this accuracy along with the RP part. How do you explain your premature claim is concerned? Because you terminate the contract on the basis of this may lead to section 8A. So how do you explain that?
Respected arbitrators, answering your question on two limbs. One, we gave them the exact specifications, which was a submission regarding the particular purpose of the contract. If I could draw your attention to page 10 of the case record, respected arbitrator, in paragraph 2, we have specified we can afford to make no mistakes. We cannot afford to be wrong due to the shaky trust of the investors and ESG compliance. That was a specification, and the particular purpose of the contract is that, and not anything else they claimed it to be. That we wanted such data which won't lead us to threats or challenges, and completely ignoring the BS report, respected arbitrator. Just a quick 30 seconds.
Answer the second question.
Yes, respected arbitrator, it's not premature, because if we rely on their analysis as well, on their report provided by Allen Gledhill, that also tells it can lead us to threats and challenges, which is the fundamental breach to our contract. Our contract wanted data which will lead us to have a successful and safe expedition without threats, without challenges, without mistakes. Their data confirmed the existence of threats. They call it insurmountable, it's not insurmountable. Respected arbitrators, the purpose of the contract has been fundamentally breached over here. The purpose of the contract wasn't the expedition, but providing this data. And if it was an honor arguing before the tribunal, and we look forward to arguing before the tribunal again at some point of time in the future. Thank you so much.
Members of the tribunal, I just have one small point and observation to make with regards to the preponderance and the aspect of services. My friend just came about and talked about Article 3 Clause 1, which is talking about when the supply is being made by buyer. And what I talked about is when the supply is being made by seller. That has to be differentiated. Article.
Do you know the warranties, states of goods and says that there are implied warranties.
Indeed,
so
sir.
when you are supplying the data, the implied warranty will be that it will be equivalent to the
Indeed, sir. Thank you.
Two, how do you explain, should they get 6 people die on that expedition, then only their claim will be made?
To answer that question, Mr. Arbitrator, I do not at all, for the second aspect answering first, Mr. Arbitrator, I am not at all contending that the expedition is to be undertaken when it is fatal. However, the same expedition is not fatal is what we are contending firstly. Secondly, if they come about and tell me that an expert report, like that of David Attenborough, who's not an expert but an experienced person, if they rely on such expert and tell me that the report that the data that we submitted is fatal, I would happily agree. However, the fact is that they are basing their entire termination on the fact that BS and artificial intelligence whose report cannot be corroborated is something which is defining our entire expedition to be fatal, which is the problem that I have. The last submission that I am having, Mr. Arbitrator, is that the differentiation that I was making, just one small point that I want to highlight on that. With regards to the services that we are rendering or the respondent is rendering as per Article 3 Clause 2 has to be differentiated with regards to what are the obligations or the specifications of the services which buyer is rendering in Article 3 Clause 1. Which is the reason I have related Article 3 Clause 2 to preponderant services of the respondent, and I am not at all talking about any data point or format or specifications which they provided us, which is the differentiation that I am trying to make.
I think to be fair, his point was perhaps that if there are allied services that are associated with delivering a set of goods like packing, etc., then that doesn't mean that it's a services contract. I don't think he was talking about the buyer providing components towards manufacture and Article 3.1. But that's fine. I just wanted to make it clear.
It was a pleasure acting.
Just confirm and we'll come. Thank you very much.